Welcome to Gloves Off, hosted by award-winning trial and personal injury attorney Ben Johnson, founder of Ben Johnson Law. In each episode, Ben goes toe-to-toe with guests, hashing out legal matters around the most talked-about news stories and issues. We don't pull any punches, so some language and topics may not be suitable for younger listeners.
Ladies and gentlemen everywhere, fighters, beware. Episode 33, Podscast. We call it Podscast now. Podcast, Gloves Off, with my partner, the Paul Doherty. Go ahead. I want sound. There it is. Chelsea on the magic Ouija board.
I'd prefer the applause and the laughter.
There we go.
That's a good way to start.
Hey, can all you people sit down in the back, please? Now we have to get busy. Thank you very much. All those hundreds of thousands that were cheering for you, Paul. Here's what I'm calling this, Paul. UIM, what you can do to protect yourself against the insurance industry. Riveting.
It's exciting stuff.
Riveting.
Now, if you're hurt and your defendant is underinsured,
it means everything.
You're damn glad.
Okay, so here's what we're going to talk about. I'm going to have Paul just give an overview of the Eller case that he was getting ready for trial. Unfortunately or fortunately, depending on one's viewpoint, it adjourned. Adjourned by trial lawyer parlance means rescheduled. And so that's going to be out in Oakland County. That's Judge Kwame Rowe, correct?
Correct.
And Paul, just give us the 2-second overview of the Eller case. Let's just talk about the typical, I hate that word when lawyers use it and try to downgrade people's importance, meaning our clients and their injuries. So tell us about the auto crash part that most people will have a pretty good idea of understanding.
Sure. Our client is driving her personal vehicle. Fortunately for her, it's insured through a policy that her father got, who owns a small manufacturing company. So she's out minding her own business one day, and a negligent driver, a guy that owns a company, you would think would have a commercial policy,
right?
Turns in front of her, and they have a big crash.
He was pulling something, wasn't he?
Pulling a big trailer. It was some kind of gutter company. So
heavier vehicle, which means harder to stop.
Yep.
Worse impact, worse injuries for our client typically. Sorry, Paul.
Lots of weight. Now, she's driving a Chevy Tahoe, big vehicle, but it rips the front suspension off, totals the vehicle. So it's a big impact. So we sue and find out, unfortunately, that the defendant has what would be a minimal $250,000 liability policy. Shockingly, it's a commercial vehicle. You'd think he'd have $1 million. He doesn't. So we tell him, Ms. Eller, unfortunately, he's only got $250,000. By the way, let's get Dad's policy and check that out. Oh,
Dad, who owns the vehicle that she was driving.
He's got insurance, and we find out that he's got a $1 million UIM provision in his policy. So what that meant then is that to the extent the underlying defendant is underinsured, her own policy kicks in up to $1 million. So that's where we're at. So we basically have $1 million worth of coverage in this case.
So the important thing for everybody out there to understand is when you are going down the road, and when we talk about uninsured motorist, the thing that comes to my mind, Paul, stereotypically is drunk driver crosses double yellow line and picks off and injures, if not kills, a car full of people. Okay, that person doesn't have insurance, the drunk. So everyone says, well, you sue the bar. Well, believe it or not, under Michigan law, it's called dram shop. It is incredibly difficult to sue and win a dram shop case. So forget that for now. You would then sue the person who's driving the car, but they have no insurance. And of course, this is their third drunk driving offense, and they're going to go to jail anyway, right, in the criminal proceedings that they're going to be charged with, like they should. And then you find out that they have no money. So you sue them. Okay. You sue them, what we do, and the way Ben Johnson Law works, a lot of other firms don't do it this way, and I swear what we do is absolutely what I think to be is standard of care, Paul. In other words, it's what you have to do to make sure your clients are fully protected. You get them to answer interrogatories. These are sworn answers to written questions. Then we get to take their depositions, and we do all of that and make them admit that they either did have insurance that day or they did not. If they don't, that means you'll never get any money from them. You then can go and look at your own policy to see if your own policy or the policy that belongs to the car that you were driving has uninsured motorists. Okay. Similar, you're now in a crash where the other person, drunk driver crossing yellow line, or in this case, a guy that ran a red light because I think he was picking up his cell phone off the front of the truck that had fallen on the ground or whatever he claimed he did. He had a $250,000 policy. Just a few years ago, Paul, we changed the mandatory minimums where it used to be $20,000 policy. It's all people had to have. Now the least you can have is $250,000. Why did the law change, Paul?
It was a part of a give and take on the PIP reform, which is the personal injury protection. So what they took away from those rights, they purported to give back by raising the limits of liability. So while injured drivers often lose out on their PIP benefits, good news is the at-fault defendant should have more money in insurance coverage.
So now the minimum is $250,000.
Which can be lower if you check certain boxes in your policies. You can get as low as 50.
Okay.
But you have to sign specific waivers reducing your liability coverage. If you don't pick those waivers, you're automatically at 250.
So in this particular case, our client has had, Paul, at least 2?
She's had 1 and she's got 1 scheduled.
Spinal surgeries. Really nice lady, young lady. She's got 5 kids, 3 natural and 2 adopted. She is just an amazing person. She's a friend of one of my Oxford high school shooting victim clients. And thank you very much, Megan, for sending us Ms. Eller. And she's been just a phenomenal person. I've gotten to know her. Paul knows her incredibly well. Just a great, great lady, and is doing everything that she can to get better. But guess what? When you have 2 spinal surgeries in your young 40s and you're raising kids and doing stuff, it's often not a very fun path. And so she's really suffered, poor lady. And so we're doing everything for her. So similar situation now. The guy doesn't have his insurance is $250,000, and now you go and look at your own company, insurance companies. Do I have underinsured motorist coverage? It means there's coverage there, but it's not enough. Clearly not enough, Paul.
Right.
So in this particular case, in fact, I was at the settlement conference right before Paul was getting ready for trial, and the driver of the other car, his lawyer knows that that guy's at fault, offers the $250,000 policy. And then my client's own insurance company is the one saying, we're not paying you a dime more. So in this case, our client's dad, Paul, paid for this big time policy of $1 million, paid all the premiums for all those years. And guess who's the one screwing him over?
His own insurance company.
Ladies and gentlemen, this happens every single day in Michigan. And hence one of the reasons why we want to do this riveting episode 33, UIM, how to protect yourself against the insurance industry. Here's what every single one of you that is bored enough to listen to this podcast should go home and do right now. They're called declaratory sheets. We call them DEC, D-E-C sheets. And we get these all in the mail, and you look at them and you throw them away. It shows you a line-by-line item of the various insurance coverages that you have on your own policies. You need to make sure that your insurance agent, whoever it is, whether you use an online something versus some dude like I do from Saginaw, Douglas MacArthur High School, Stevie Smith, my buddy. He runs my insurance for me. That's what he does. I make sure that he gets me UM and UIM. Why? Because he will openly tell you the insurance companies don't want to write that coverage. Paul, how does that make sense? They get to charge us for premiums, which therefore means we're adding to their profits. Why would they not want to write coverages for UM and UIM?
Well, it increases their exposure when someone else...
Which means what?
It means their potential payout to you when somebody else causes the damage that they don't insure.
Right.
Okay. Now, just a little more historical. Years ago, very few people had this coverage at all.
Right. They don't even tell you half the time, Paul.
Right. Now it's more common, but the limits of liability will only equal your limit. So if you have a $250 policy yourself, they'll only write you a $250. And now that most people have $250, that means you're paying for coverage you probably will never use because the other driver's going to have $250. You have to have more than $250.
So that's why what I do, ladies and gentlemen, is every time I re-up on my insurance or go get new insurance, I always try to increase the policy limits of my UM and my UIM. Okay. So what they want to do with me is they say, okay, Ven, you drive everywhere. You're always at work. You need to have higher policy limits. God forbid if you make a mistake and hurt somebody. And they're right, because if I get sued, I'm going to turn it over to my insurance company, just like you all would, and have them represent me, and then they have to pay for it. I want to make sure that my policy limits are high enough, so God forbid, like in this case, if I injured somebody like Ms. Eller and she had multiple surgeries, that there's enough policy limit to take care of it before they come and sue me individually above and beyond that to pay that out of my pocket. So then what I say is, if I'm going to pay for all this added coverage, I want you to match how much my policy limits are with my UM and UIM. And guess what? The number one thing I have difficulty in getting insurance companies to do, exactly that. They don't like it. They don't want to sell it to you. So ladies and gentlemen, I don't care how small or how big your insurance policies are, you better have UM and UIM because you're taking care of you. And that's why they don't like selling it to you. Go ask your agent to tell you and give you a quote. And what you end up finding, Paul, is the quotes comparatively to liability on the money that you'd pay somebody else if you screwed up are pennies in the dollar. Yeah. It's cheaper.
It's cheap coverage.
It's cheaper coverage for them, and they still don't want to sell it to you. So in this particular case, you're going to go home and you're going to ask your agent or go online for your declaratory or DEC page, and I want to see how much is my uninsured motorist UM or my underinsured motorist UIM. All right, Paul. So now you're getting ready for trial. You got the $250 on the table from as we call him, the at-fault driver, the dude that was driving the other truck that ran the red light. So now what happens now that they've put $250 on the table? Because that's $250. You said that our client's dad's policy was $1 million. How much can you sue for? Bad English. How much can you sue for under that scenario?
$750. The difference between what the defendant has and what your policy limits are. They get to set off the $250 that the other defendant pays.
So the $1 million total coverage, subtract the $250 that the other driver is going to pay. So now you are in court fighting over $750,000.
Correct.
Which is substantial. It's $750,000. So why would they do this, Paul? Why this company who represents our client's dad that paid all this premium dollars to it, why would they roll the dice and say, we're going to go ahead and try this case instead of just pay a settlement amount?
One, the most they'll have to pay is $750. So they figure, we got no downside given what Crazy Ven and Paul are asking for or will ask the jury for. We can ask for $10 million if we got it. They only pay us $750. There's no real downside to not settling. Secondly, they have through counsel said, we don't think your case is even worth $250.
Which is complete bullshit.
It's total horseshit or bullshit, whatever animal you like to compare it to.
So in this particular case, guys, what happens in UM and UIM cases, because of what Paul just said, the downside to the insurance company, here's what they look at. No matter how big of a verdict that Paul is it Henry?
Yeah.
Henry Gordon are going to get in Oakland County. So let's just say that they ask for $10 million, they give them $10 million. The worst possible scenario for us is we owe $750. So let's just roll the dice. Maybe the jury will take it easy on us and award something far less. So they're simply doing it on the whimsical chance that a jury will not fully award our client the money that she's owed. That's the only reason why they're trying this case. And one of the things that is lacking in UM and UIM, Paul, is a bad faith component. Boy, we're getting deep into insurance, guys, but I'm telling you, this conversation and this podcast, you could ask any lawyer that does what we do. This is what's out there going on every day now, and this is how people like you get screwed over if you don't have the right coverages. Paul, first of all, this is not a bad faith situation. We're going to explain why, but what is bad faith insurance law? What's it mean?
Bad faith is a theory that every insurance company owes you as a policy holder the duty of good faith and fair dealing. That extends to if somebody sues you. In other words, the insurance company has to deal with the plaintiff on a good faith basis. In this situation, this is a pure contract between Ms. Eller and this insurance company. So if they breach the contract, the only thing they owe is the contract damages. There's no kicker or add-on for failing to deal with
the $750 we talked about.
Yeah, and she can't get more than that. So it's not like they could have had a chance to settle within policy, but they got hit for more.
All right. Now we're going to talk about Novak. Woo, segue. So Novak was a case, we've done a couple podcasts on it. We've talked about it, where they had a $6 million insurance policy, and these idiots, it's West Bend Insurance Company. Let me spell it for you. W-E-S-T, Bend, B-E-N-D. So West Bend thought they would show Ben Johnson and his client, who's boss, we're not going to pay you the $6 million, even though your client went through 3 surgeries, Johnson, in Wayne County Circuit Court. We're going to roll the dice just like we always do, because at the very least, you can get $6 million, but you're going to ask for a lot more than that. I did. And guess what? We got over $20 million. Because of bad faith, and now in that particular situation, what we could show is the insurance company basically said, screw you, the company that did this to our guy. So this was a corporation that bought this insurance policy. That insurance company, West Bend, did I spell West Bend? I did. Insert the spelling again. West Bend Insurance Company.
And you didn't misspell it either.
I didn't for once. And by the way, the first letter of West was capitalized, Paul.
Okay.
All right.
Good enough.
That's clear. The fact of the matter is they thought they would be cute. And what happened is we got a $20 million verdict, Paul. And then after the case, the company that did this to my client sued their own insurance company, said, you guys committed bad faith. You should have paid those policy limits for $6 million so that Johnson would have taken that money and dismissed the case, and then we wouldn't have to pay the 20 minus 6, $14+ million out of our pocket. And they were right. That case is still going on, but they're right. So right now, because of that, this West Bend Insurance Company and this other corporation that did this to my client, they owe over $23 million as of the next week, actually. Just that's how we're down to the point. Where bad faith came in is because in that area, you could sue them for bad faith and get more money than the policy limits was actually in existence. Doesn't apply in UM and UIM. Why not, Paul?
Well, because, again, you can't get hit as a defendant for more than your insurance. They won't owe any more than the insurance.
All right, but you're not talking fairness. Fuck fairness. This is justice. If they are trying cases like they're doing all across Michigan, and by the way, this isn't only happening in Michigan, but Michigan is one of the biggest ones that they have out there, simply because of the no downside, and they're rolling the dice, and these are clogging up our courts and so forth and so on. My position is bad faith. Can it apply if the law changes?
Well, yeah, they'd have to change contract law in Michigan.
So one of the things that is currently going on right now behind the scenes, but especially by lawyers like us that represent victims, is we are trying to get an extension of bad faith law to take effect in UM and UIM. So when these insurance companies do exactly what they're doing in this case, and here's how obvious this case is that it's worth $750. 2 surgeries, we said, right? 2 surgeries on someone that did absolutely nothing wrong in her spine, that did not have major back or neck problems before at all. In Michigan, that 2 surgeries is worth well over $1 million. I don't care what county you're in, okay? And here, it's the only reason they're trying this case is because bad faith law doesn't apply to it, or they would. So my position is, if we're trying to encourage, and one of the things about the law that we're supposed to be doing, laws they're passed for many reasons. One of them, of course, is to promote safety and fairness and justice. And if we want insurance companies to do the right thing, what we have to do, in my opinion, is extend bad faith law into UM and UIM so that when these insurance companies are screwing around and simply trying these cases, because there's not much downside to it, they get punished, or they can be punished if it rises to the level of bad faith. Paul, thoughts?
There has to be some incentive to force these people to do the right thing. It's kind of like medical malpractice caps. You know, if you got a low cap case, you've got an elderly person who died, clear negligence, the carrier knows the most we owe is $575, $580. So we'll offer you $4 million, even though the case is worth $5 million, because the worst that can happen to us is we get hit for $560. Same thing here. There's just no incentive to be fair with these people.
Did you all know there's medical malpractice damage caps out there? My daughter did a paper on that in high school. I know she knows. But these caps in medical malpractice cases, y'all, have been in effect now for over 20 years. And the majority of people, including the doctors who benefit from it and hospitals, don't even know it. So we'll do that another episode. But as it relates to UM and UIM, what are they going to go home and do, Paul? Today.
I think check their deck page. Is that what you were
look at her.
suggesting?
I love that.
I think.
He listens.
I get some help out there?
He does love me. Oh, thank you. Thank you, Chelsea. All right.
Now, let me add one other thing.
Please do.
Mr. Johnson.
Yes, sir.
In my case, in my personal life, I have an umbrella policy, okay, which provides additional coverage to me if I unfortunately hurt somebody.
We call that, first of all, primary, your initial thing. And if you have trying to avoid something from going above and beyond that you'd pay out of your pocket, you have, it's either excess or an umbrella policy is what we call it. Same thing. Go ahead, Paul.
And if you have a good agent, he or she can give you the ins and outs and how much that costs. Again, it's not real expensive coverage, but my umbrella policy has exact coverage for UIM. So the amount of my umbrella, I also have UIM. So basically, you should carry a minimum of $500,000 liability in Michigan, period. You should then have matching UIM of $500,000. If you've got a
bare
house,
minimum.
If you have a house, if you own your house, you have any assets, a bank account, consider getting an umbrella policy for $1 million. They'll sell you UIM in that $1 million policy. Now you've got $1.5 million of coverage no matter who runs into you. And my point is you're more likely to be run into by someone irresponsible
Correct.
than someone responsible, meaning
Correct.
either they're going to be underinsured or uninsured. I drive
No
through
insurance
Detroit
there.
every day, and even so with reforms, there's been a lot better coverage options in Detroit, but it's still outrageously expensive. So the odds of being hit by somebody uninsured or underinsured driving through the city of Detroit is more significant than driving through Bloomfield Hills, let's put it. So
You mean in terms of the likelihood of inadequate or no coverage whatsoever
correct,
on their
because
part?
the exorbitant insurance rates in the city of Detroit, many folks can't afford basic coverage.
All right, so when you go home and check your deck pages and you find out, oh my God, I don't have UM and UIM, talk to your agent and find out what your policy limits are. How much would you guys have to pay, or would you pay up to that amount if, God forbid, I injured somebody? And then you're going to want to get your UM and your UIM. You want to get a quote for how much it would cost you to add that policy to your underlying policy so that you're protecting yourself. Don't, as my mother would say, don't ever say I never gave you nothing. Grandma Johnson. What else, Paul? Pearls of wisdom. We're going to sign off.
One other pearl, if you're concerned about your rates, the driving rate in your policy is often your collision coverage. Okay, you can. I had kids on policies. I always had a $1,000 deductible. I'm not going to do the fender benders, all that. I do it myself. So if you want to lower your rates, get a high deductible, $1,000. That will keep your policy premium down, and you can have the real important coverage, UIM, which doesn't cost you a lot. So don't let the cost of insurance necessarily scare you away from this coverage.
And by the way, in terms of the cost of insurance, which everyone could probably agree it's too high, the fact of the matter, it's the law. So if you don't have coverage, don't get behind a wheel. I'll tell you something right now, folks. They will go after you criminally now like never before, because if you've known that you didn't have insurance and you were out there driving, it's a no-no. And again, like Paul talked about, the accident rates for folks that don't have any coverage or inadequate coverage are much higher than, quote, normal. And so they will go after you criminally as well, let alone civilly. So, all right, Paul Doherty, great to see you. Thank you very much, and you're welcome for that coffee. And by the way, I want to dispel any rumors that Perrier, as we'd say in Saginaw, they are not an official sponsor. In the event that you would like to sponsor this program, please call Ari Johnson, Guajardo Oak right now. Signing off, y'all. Have a good one.
Ciao.